we've got here the state case. This is in the 9th District of Florida in Orange County, Florida, not California, Orange County, Florida. This is case number 2023 CA 0118180, the Central Florida Tourism Oversight District versus Walt Disney World Parks and Resorts, Inc. So this is in front of Judge Margaret Schreiber. You've got the correct parties, so the CFTOD, the Special District, and Walt Disney World Parks. Remember, in the state case, DeSantis is not a party. So DeSantis is not in the state case at all. So this has nothing to do with DeSantis. Now, did DeSantis appoint the board of the district? Yes. Now, mind you, that was also, the board was appointed by DeSantis but confirmed by the legislature. So it's not just solely DeSantis. It's DeSantis and the government, the duly elected government, both the governor being elected and the state representatives being elected, that appointed these people and confirmed these people. So these were confirmed by the people. Much different than the entirely Disney-controlled board and hand-picked board. You might even say the groomed board that was up there before when this was under Disney control. And now we have the timeline here. So we've got all the Disney lawyers. They all appeared. We've got that information in there. And here we had a Disney motion to dismiss. They actually filed a motion to dismiss back here on May 16th. So on the 20th of June, we have a response. This is an amended response, which I've yet to go through, in opposition to Disney's attempt to dismiss this. So this is going to be the district, i.e. the new special district, fighting against Disney. So I'm giving you these points, and we're going to summarize what the arguments are. So Disney was arguing, essentially, to give you a summary of what Disney wanted. Disney wants to dismiss the state case. So Disney wants the federal case. The CFTOD wants the state case to stick around. So both parties, right, want to dismiss the other case. So these two cases, DeSantis and the district, they want it just to be the state case. And by the way, if you're asking me my legal opinion as a Florida lawyer, this is quintessential Florida law. So I agree with the CFTOD and with DeSantis that this is properly in state court, not federal court. This is a state law issue. So I do agree with the CFTOD. I do agree with DeSantis in summary. But I just want to make that very clear on who wants what. I know it can get a little confusing sometimes. So Disney said, hey, this state case, it's moot because we have this federal case. And also because the state legislature already voided our developer agreements. They found them void ab initio, which means as if they never existed. So the state case is moot. Well, the states come back and the CFTODs come back and said, that's not the case. They are not moot. Oh, and by the way, Don, I'm happy to collaborate with whoever. So let them know I am always happy to collaborate with whatever, especially a hottie. I mean, always down for that. I mean, if you want to see that, we're gonna have a lot of hotties on Bangkok Bros. You guys should subscribe to that as we make that channel more and more fun every day. But anyways, so these guys in this case are saying that that Disney is saying that the state case is moot. So let's see the response here, and this is the response of the district of the state, which is, this case is not moot and a stay is not proper. So a stay would pause the state case. So they're saying, yep, that's not okay, not proper. Why? Well, here's why. And this quote is perfect. Disney's motion is classic Imagineering, inviting the court to believe that reality is whatever Disney dreams up. I love that. Disney first tells the court that Senate Bill 1604 is a valid law that moots Disney's claims, but then makes the argument that Disney must hope this court will ignore Disney's claim in federal court that 1604 is unconstitutional. This is what I've been saying all the time. Disney is literally pretending that the state court can't read. Disney thinks that people and judges are mentally challenged, that they are unable to read anything that Disney does not put in writing. This to me is the most jarring thing. Now, I will say this. Maybe Disney's fans are missing something upstairs. Maybe they've snorted enough pixie dust that there's a hole in their cranium. But in Disney's federal case, they are still have not amended their complaints. They are still trying to fight these laws, which they say are unconstitutional. So if they're trying to fight those laws in a lawsuit, well, it can't be moot. You don't fight something that's moot. You just give up that issue. You concede that issue. So this, I think, is just a killer fact here. Absolutely killer. By the way, welcome, Brandon the Anime Guy. I'm going to be on your channel and talk about isekai very shortly in the future. So appreciate that. Welcome once again. Welcome to the BLM, the Base Legal Mindset, the best membership community out there. And for those that aren't members, get on the Base Legal Mindset. Great membership community and a lot of members exclusive content coming. And Jameson said, I despise Ron, but he is right here. Law's law. And thank you for that, Jameson, because here's the thing. You can think somebody is an asshole. You can disagree with somebody. In fact, that's what I said about Eric Hunley earlier, right? I may disagree with Eric on things. There's takes that Eric has had that I think are 100% wrong and that he is wrong about. But the law is the law. And when I talked about journalistic privilege, he's covered by that, regardless of whatever bad takes he's had. Ron DeSantis, you may disagree with him on a lot of things. You may think his presidential run is horrible, that he's put up there by whoever, that you don't like who he associates with. That's fine. But he's correct under the law here. And we just got to call it correctly. That's the difference between people who are deranged and not. People who are thinking in a sane way of say, look, this is correct under the law. It's just like due process. Someone can be a bad person, but they can still be correct because they need to be given the right process, procedure, everything else. There's a system here. And we've got to follow these systems. And Brandon also says, daily reminder to Doug Fisney. Appreciate that. Raw is raw. It's very true. Yeah, the law is a law. As long as the law is constitutional, we should abide by it. Yeah, there's no two-tier system. There's no two-tier justice. So let me go here. In reality, the district suits is a live controversy whose resolution will have an actual effect on the federal action because, and here we go, guys, this is what I have been saying the entire time. Let me read this. This is what Disney's lawyers, this is what a Supreme Court justice in Florida is agreeing with me on. If Disney's contracts are void, nearly all of Disney's claims in the federal case disappear. I have been saying this since Jump Street, since day one. And I am glad, by the way, that they are listening to my argument. And I know some people, they were in the comments like, Andrew, they're not actually listening to you. Actually, no. We have confirmed that they are forwarding over our videos, Valiant Renegades videos, WW Pro videos, my videos, over on this topic, especially the legal comments. They're watching. They're listening. They're forwarding these over. So yes, they've heard the arguments and they've incorporated them now. This is beautiful. I love to see this. This is the correct argument here. And nobody in the mainstream media is making this. None of the pixie dusters understand this. That if Disney's contracts in the state case are void, their federal case is gone. They got nothing. They got nothing. They will be automatically dismissed from court. Some guy with cancer says, sitting in the hospital right now, had 2 stents in my bile duct, but Disney clearly stole some anesthesia to treat this up. Man, I wish you the best. And it is so awesome that you maintain that sense of levity despite being in a hard place. That is so important. Never give that up. Never give up your sense of levity, your sense of humor, your sense of joy, no matter when they try to take it from you. And by the way, Disney used to be that source of joy and levity. And it is so sad that they're not that source anymore. But you're absolutely right about Disney's delusion. And by the way, I do wish you the best for your speedy recovery, and I hope you get out of there as soon as possible. Paulo, welcome to the replay game, the RPG as a member. Appreciate you, Paulo Fieri. Appreciate you here very much. 2012 Jameson says Disney has a lot of DTPA, the Deceptive Practices Trade Act. They have a lot of issues. Yes, they certainly do. In terms of advertising, what they've advertised, what they haven't followed through on, what they've said, I think they've got a whole host of legal issues. I completely agree with you on that. Disney then tells the courts, to continue with this, that this case in favor of Disney's federal case in Tallahassee. So they want the case to be heard in a different court other than Orlando, or Orange County rather, where Disney World exists. So Disney wants this case to be removed from where it should actually be tried, which is locally in the place where Disney is located. That is where it should be, in a state court. So Disney must pretend that this court and the federal court share concurrent jurisdiction needed to invoke the priority principle, and that federal court got jurisdiction first, and that this case and the federal case involved the same thing. When reality is that this case is about whether the two contracts are void, while Disney's federal case is about whether the governor and other individuals violated the federal constitution. Two different things. And this thing, particularly this last thing, this pretending the state and federal case are the same thing, like, oh, it's a suit and a countersuit. Guys, honestly, when people use countersuit, that's not really right. The state case is not a countersuit. A countersuit, to explain to you, is when you have a lawsuit. Let's say it's for like a car accident. And let's say there's multiple parties. Let's say there's like 5 cars involved. So I sue Don Baca, because it's in the car accident is me, Don Baca, and Danielle. It's all the mods, they all got in a big car accident. So I sue Don Baca. Don Baca countersues me and Danielle. And then Danielle sues Don Baca and me. We're all suing each other. That's a countersuit because it's all about the same car accident. This is like not just car accidents, no one car accident. This is like they're comparing the Ocean Gate implosion to the Challenger shuttle in a different decade. This is so different. It's apples and oranges. It's completely different. The question is completely different. And of course, the federal question, the constitutional question, is a ridiculous question, but they're entirely different. One is state law pertaining to special districts and local government. The other one is, does this violate free speech? And by the way, the free speech claim is the only one that would even sort of be around after the state case is decided, but it would be promptly dismissed because it's a ridiculous argument. It's a ridiculous argument. So let's get a little bit of this background before I get into some of the legal arguments they drop here and summarize them. I'm going to summarize the legal arguments, but I want to give you the background because this is actually really good background. Here it is. For relevant background, for 55 years, Disney enjoyed a privilege no business in Florida has enjoyed: the ability to handpick its own local government with powers rivaling the county or city and wield those powers as Disney saw fit. To be clear, there are other special districts that are picked by landowners. However, most of those are multiple landowners, not a single landowner. That's a big difference. For example, Bonnet Creek, a district I represented that is right next to Disney, that is 100% controlled by landowners, okay? 100%. Bonnet Creek is 100% controlled by landowners. If you guys have ever been there, the Wyndham, the Waldorf, you got the JW. All of these landowners have a different representative on the board, and they all have a say. So all of these people on the board, they represent different people, and they come together for their shared interest in, hey, we want to make the common area look good. We want to make the roads look good. We want to take care of this conservation land. They do it together as a team. They don't dictate it from one party to everybody else. That's how most landowner districts that stay around for a long time should work. Now, when a developer just starts a new area, like a new community, they typically do control it. So back in 1967, it probably was appropriate for Disney to control that district for maybe 5 years or maybe even 10 years as they got it up and running. But remember, they promised Epcot, they promised the city. So the thought was the citizens of the city would eventually take over. At least that's what the legislator thought. Turns out that city never happened, for better or for worse. Some people say it's a good thing it never happened. I'm willing to entertain that. But that being said, they never followed through on that promise. So Disney got to keep these unchecked powers, nuclear power plant, airport, no regulations that were actually enforced against them. The fire code, the building code was never enforced against them. They're exempt from taxation. They're exempt from regulation by the city and county. Nobody else has that. No other special districts has that. And somebody asked, are special districts a Florida thing? There are other states that have them, but Florida has the most. And this is why I specialized in it, because it was a special Florida thing. And even though they do sort of exist, the laws are different. Florida laws are very specific to Florida. They're not federal. They are a state thing. Jameson said, technically it's issue preclusion. Yeah, it is issue in terms of the contract. So in terms of the contracts, the state case has to be decided first, because like they said, in terms of issue preclusion, and this is correct, we need to first determine whether or not the contracts are valid, because that's why Disney is suing. That's one of the grounds they're suing on 4 out of 5 of their claims. They're suing based on those contracts. So we've got to decide whether those contracts are valid. That's a state case thing. So if anything, it just proves the state's point. Georgia P says, what is the worst case scenario for Disney with these suits, and how do you think it will end? I'm going to bring this up, Georgia Peach. This video has been a clip of a previous live stream, and it's clipped so you can get the information in a shorter, compact package, the information you need. If you want the full video, the whole context, the whole thing, you can check out the full stream. That is in the link below. Check that out, and I will catch you guys later. Peace.